Yes, Mr. Waite.
My lords, my lady, I appear on behalf of the appellant.
Well, I don't think you do you, Mr.
I do in terms of the nominal appellant. Your lordships may have noticed in the bundle, in the supplementary bundle, because it's been filed in evidence from the outset that Kennedy's and myself have always been instructed on behalf of the insurer.
Who is the insurer?
The insurer is Angel Risk Management and
Sorry, who?
Angel Risk Management and AXA XL Insurance Company UK Limited.
Is there any document in the papers that gives us the precise identity?
In terms of being named, no, not in the.
Right, well, I think we'll need to have some form of open document filed with the identity of the insurers. Can you just give me the reference, please, in the supplementary bundle to the letter that you refer to?
It is the witness statement of Mr. Ruendahl, and it's at page number, it's in the supplementary bundle.
Well, is this the bundle that came through yesterday? No, go on. Page which?
One moment. It's at page number 256.
Thank you. Right. My firm was instructed on behalf of the defendant's insurer on the 5th of May 2022. That's it, is it?
Yes.
Right. I mean, in all frankness, Mr. Waite, I think we were expecting some sort of skeleton argument, or a note, at least, telling us how you think you can proceed today, and on what basis.
Yes.
We understand that although you were aware of the insolvency process, and indeed so was Mr. Wibberley's clients, because they apparently objected to it, according to some of the correspondence we've seen. You were not tracking the process and were not aware of the company's voluntary striking off and dissolution on the 29th of October 2024 until this week. Is that correct?
Yes. Well,
Right.
until I think it was last Thursday when we were informed by the claimant solicitors.
Right. So there is no longer, the appellant no longer exists.
No, it doesn't exist. It's been voluntarily dissolved.
Yep. And how do you say the appeal can proceed today?
Yes, I'm grateful to my lady for that, because that's how I was proposing to deal with this.
Well, I think we need to deal with it as a preliminary issue,
Indeed.
hearing on both sides, and then we'll see how we go forward.
Indeed. Can I first of all just begin by checking whether the court has received the reference to both section 51 in the email that I sent this morning, as well as rule 46.2. My lady, having been informed and receiving the email that I did yesterday, I took urgent instructions overnight. I have...
what email? Received what email?
The email from this court.
Oh, yes, yes, indeed. Yep, thank you.
Want to hear submissions from us on this point. We had not appreciated that the point was being pursued, given that we had informed the claimant solicitors that, or reminded, I should say, the claimant solicitors, that Kennedy's have always taken instructions from the insurers, and it's the insurers.
That doesn't meet the point, does it, Mr. Waite? I mean, the appellant doesn't exist.
Yes, there's a solution I'm going to propose.
Good, all right.
I've put forward this solution to Mr. Wibberley.
It's not really about taking the point. I mean, you know, there's a point of substance. We can't hear an appeal without the appeal being properly constituted.
The solution and the way to get around this problem in terms of how this appeal is constituted is to add the insurer as a party to these proceedings, which are cost-only proceedings, under section 51 and rule 46.2 of the CPR.
Yes? Alternatively, CPR 19, but you don't think you need that?
I don't think we need that, because these are only cost-only proceedings. Can I just make this point? There are no proceedings as such to either defend or to bring. The proceedings barely got off. The court declined jurisdiction for late service of the claim form. All that these appeals have been focused on is whether the judge who made the cost order at first instance was right, and whether that cost order should be restored. There is a cost order it's a cost order that is unenforceable at present because of the operation of the qualified one-way cost shifting regime.
So has anything been paid by insurers by way of costs?
The insurers have paid their own solicitors' costs. They have a liability to pay,
Has not been met.
which is, and there's, I believe, a stay of execution on the costs order below. But they have a liability, and the claimant solicitors have been given the assurance that come what may, if this appeal is ultimately unsuccessful, the insurers will be paying the costs of that appeal. If we just step back one moment, the costs order that is in favour of the claimants that was made down below by His Honour Judge Owen, as we understand the Third Party Rights Against the Insurers Act, that costs order becomes directly enforceable at the moment that
For what it's
Heritage...
worth, I agree with that. I don't
Yes.
know about my lords, but I agree with that, and I suspect Mr. Wibberley also agrees with that.
Yes, and therefore we are only concerned with the costs order that was made in the defendant's favour. This has always been a case in which the benefit and the burden of any cost liability would always be met by the insurer. The insurer has to pay the costs if unsuccessful, and the insurer gets its costs that it has outlaid if successful. And therefore, the real party to this appeal is the insurer, because it is the insurer that has defended the case, and it's the insurer that is appealing for the recovery of its costs. We don't see, or we submit, that there is little point in making an application to restore Heritage Independent Living Ltd to the company register under the Companies Act in circumstances where there is effectively no claim. The proceedings are came to an end from the very outset, and Heritage, of course, does not get the benefit of those costs. Any order that's made in the defendant's favour for those costs will simply be transferred to the defendant's insurer. And for those reasons, we submit that perhaps the most pragmatic solution to this problem is for the court to permit Angel Risk Management and AXA XL Insurance.
Hold on, Angel Risk Management.
And AXA XL Insurance Company UK Limited to be added as a party.
Because we are considering, are we, whether to make a costs order against them?
Yes, I mean, if the claim is ultimately, if the appeal is ultimately unsuccessful, the insurers will be meeting those costs. We've given that assurance in writing.
And when did you tell Mr. Wibberley about this application?
I've discussed it this morning with Mr. Wibberley, following my conference that I had yesterday evening to take instructions from my solicitor.
So you and your solicitors took the position that actually, until you heard from the court, that you could just turn up this morning and pursue an appeal on behalf of a company that didn't exist?
Well, my lady, we put it in writing, the proposal, that there would be no difficulties with the insurers continuing. The mechanics of how that works is something that I have discussed this morning with Mr. Wibberley. But when my instructing solicitors were notified by the claimant's instructing solicitors of this issue, they responded promptly and pointed out that because of the reality, because this is an appeal that is being pursued by the insurers, that the claim can still be, or that the appeal can still be preserved.
Now, you've got a very experienced firm of solicitors behind you. You're on notice that insolvency proceedings are underway against the company. Why was the position not being tracked?
As I understand the matter, the position was tracked initially. An objection was raised. That objection, as we understood it, was accepted by Companies House. We've had no instructions from Heritage Independent Living. This is the instructions for the purposes of this appeal have come from the insurers.
But why is that different from any case in which a defendant is insured? That's always the right of the insurer under a standard insurance contract to conduct the proceedings on behalf of the insured. But it doesn't mean that the insurer can suddenly magically become a party when the party dies or is dissolved.
My Lord, these are proceedings that have come to an end. This is only cost proceedings.
Yes, but
Yeah,
they
but
were
that's
proceedings.
They were.
All you're saying, really, is that the only remaining issue is costs.
That is right.
They were not costs proceedings when they began.
No.
They were a claim for damages.
Well, if we step back, there were a claim for damages. Instructions would have been given by Heritage Independent Living at the time, and that was back in 2022.
Yeah.
You can say that at the time of dissolution, it was costs-only proceedings.
It was.
At the point of Heritage's solution, this October, there were only costs-only proceedings.
That is right. Yes, the appeal has only been on.
I'm trying to help you and answer one of my Lord's points. Yeah.
Well, I raised that
Perhaps
because
I'm not getting your Lordship's point.
Well, my point was that there is a technical meaning to costs-only proceedings. That is,
Yes.
proceedings which are brought only for the purposes of recovering costs and
Yes.
not for any other purpose. That's not this case. This
No.
case was a normal action for damages, which came to an end, and then all that was left was a dispute about costs. So
Yes,
I don't
but-
really see how that makes good your point that it doesn't really matter who the named party is,
Yes.
because, as is entirely common, insurers are going to be picking up the tab or getting the costs back if they succeed.
Yes. My Lord, I was using, just to correct myself, and forgive me, I was using the expression costs-only proceedings in the context as they're envisaged in 46.2,
Yeah.
where the court exercises its power under Section 51. Perhaps I used it too loosely in that sense.
Mr. Wake, can I-
But the appeal has been, as I don't think there's any argument about it, the appeal is simply to restore the order the costs order that was made at first instance.
Mr. Wake, can I make sure I've understood your point? As I understand it, the critical piece in your reasoning is you say once the costs order was made, the effect of the insurance legislation means that as a matter of law, your clients are liable to pay those costs.
Yes.
And that arises when the company is dissolved. Ability under the insurance legislation. So the insurers are now in a position where they do have a legal liability on the face of, as a result of the operation of the order the court made against the company, which doesn't exist now.
Yes.
Plus the insurance legislation.
That's right.
It's not just the insurer in the context of a subrogated claim, as it were, doing what's right. It's actually, as a matter of law, your
Yes.
clients are now liable for those costs if that order stands. And that's why your client, calling your client, that's why the insurer has a direct interest in the matter of this appeal. That's your point, as I understand.
That is my point. And my Lord, I think the terminology that's used in insurance law is that there's an assignment by operation of law under the Act, as opposed to an assignment contractually. But your Lordship's absolutely right that there was an obligation to pay those costs before the dissolution by reason of the subrogated relationship between the defendant and its insurer, and upon the defendant's dissolution, as a matter of law, by operation of law, if I could put it that way, the right for the claimant to have their costs paid vests in the claimant, because the claimant effectively stands in the shoes of the insured. And so for all intents and purposes, I would submit to the court that those are compelling reasons to accede to our proposed solution as a way around the difficulties that we're in.
Good. All right. Let's hear from Mr. Wibberley. Thank you. Yes.
Thank you, Milady. The starting point, it seems to us, and I say this bearing in mind that we were the party monitoring the strikeout proceedings, and they were not insolvency proceedings. The company petitioned, or I say petitioned, it was the director of the company who filed notice that he wished to dissolve the company. I'm told that we warned that off for 6 months. We then went back before the expiry of the 6-month period to warn it off again. We were told by Companies House that the director had discontinued the dissolution of the company and therefore we could not warn it off again. It appears that what we were told by Companies House is incorrect, and on the end of the 6 months, or shortly after the 6 months expiring, the company was simply dissolved on the director's original
So
application.
the director hadn't discontinued?
Sorry.
The director had not discontinued?
Correct. And Companies House now are querying whether they ever told us that in the first place.
Right, okay.
But so that is how we get to where we are.
Yep.
The reason that we have focused on the company is, though, and I'll address some of the points made by my learned friend in a second. The starting point of this case is that an order for costs is made in favour of the company, and the primary question between the parties, the real reason we're here is that order in favour of the company enforceable? That was the primary reason for the appeal at first instance. That's the primary reason underpinning the appeal today. And that costs order made in favour of the company is a legal right previously owned by the company. Now, it may be that the insurers are entitled to be subrogated to that right because they paid, we assume, Kennedy's costs of defending the proceedings at first instance. And I say we assume because we've not seen any evidence of payment, so it's unclear as to whether or not rights of subrogation have in fact arisen. But even if they have arisen, the point being that the insurers have a right against the insured, but the costs order, the cause of action, remains vested in the insured. And so these proceedings are proceedings to establish the enforceability of a legal right previously owned by the company and now bona vacantia. I make that for two reasons. One, because it...
The answer that if I mean, speaking entirely for myself, the broad merits of the situation, the broad merits, favour getting on with this.
Yes.
I'm speaking entirely for myself. If the order in favour of the company is restored, i.e. the appeal succeeds, then one option might be, if you're right that the benefit lies in a company which no longer exists, one could then apply to restore the company. Yes. And we haven't got there yet because we haven't heard the appeal. But that would be one way through, wouldn't it, if your analysis in relation to this...
I agree, and I suppose I was simply making the point that even if they are successful, the company's going to have to be restored at some point in time.
Okay,
and there's no short circuit to that.
I don't know whether my lords are... Yes, okay. Yep, thank you. So that's a point that would arise potentially down the line.
Yes.
If the appeal were to succeed and we aren't there. The real question is what to do today. I don't think we can proceed, again, speaking for myself, with an appeal in the name of something that doesn't exist. Subrogated rights or not.
I agree on the basis that even if there are subrogated rights, they're equitable rights, not legal rights. In terms of the insurer being added, our concern, and this is, I suppose, a technical procedural concern, is the status upon which the insurer would be added, and it seems to us that the only way in which the insurer can pursue the appeal is if the insurer is added qua appellate, as opposed to simply being added for costs-only purposes.
It's not being added, it's being substituted for.
Yes and no, save that there's no substitution normally connotes a swapping out, but that's probably a lawyer's dancing on the head of a pin. The insurer needs to become, or the insurers need to become the appellates. Yep. They can't simply be added in, as one sometimes sees at the end of a substantive case where you add a third party to cost-only proceedings.
Yes, it probably doesn't matter. We could just, as you say, we could keep him in, keep the company in, on some unidentified basis. But add, I understand fully the point. The insurers have to be appellants.
But I agree entirely with the sense in pushing on it. Simply, if the insurers are to be added, I don't think it can be said that these are costs-only proceedings, because that has a specific meaning under 4614, which I think was my lordship's point.
Yes.
These are proceedings for something else in which the only remaining issue is costs. So if the insurers to come in, the insurers have to come in as a full party. I accept they have an interest in the outcome of these proceedings because, as my learned friend says, when the order was made by His Honour Judge Owen, there was a cost order against the company at the time the company existed. Assuming that is an insured liability, and we're told it is, I agree that there is a statutory assignment under the Rights Against Insurers Act, so that right becomes enforceable as against the insurers, albeit the insurers never have a direct right in relation to the underlying. But as your ladyship says, it may be that that is a bridge we cross later on, subject to the outcome of the appeal. Yeah. So I'm not trying to raise a principled objection. I'm simply saying that as a matter of procedure, if it's done, it has to be done in that way, as opposed to the insurers thinking they can come in on some sort of half basis whereby they're only party for cost purposes. If they're in, they're in, and they're in as appellates.
Understood. Thank you very much. Very helpful. Mr. Waite?
May I just turn my back for one moment in light of that suggestion?
I think that's right, isn't it? We've got to have somebody, a living, breathing appellant.
For costs as well.
Yeah, yeah.
Because
Yes.
Yes, I have instructions that we would consent.
Good. Well, we'll rise and decide where we're going to go with this. Hopefully we'll be back in short order if you stay in court. Thank you. Thank you. Mr. Waite, Mr. Wibberley, we will direct that Angel Risk Management and AXA XL Insurance Company UK Limited be joined to this appeal as an appellant, and the appeal will proceed accordingly. We will reserve the costs of what effectively is an application. We've made our comments about timing and presentation. This should have been dealt with in a different way, Mr. Waite, earlier, with proper note to the court giving Mr. Wibberley proper notice as well of what your proposed solution, as you put it, is. But let's get on with the substantive appeal now.
I'm grateful.
Mr.
And
Reserve, you happy with that? Thank you.
my lady, you indicated that you wanted something in writing. Would you
Well,
like us
I've
to
now
undertake?
managed to,
Yeah.
I hope, accurately identify the name of the insurer.
Yes.
So that will do. But we probably should have just an open email because I haven't seen this name anywhere for purposes of spelling and other accuracy.
Yes.
Yeah.
Yeah.
And would an email suffice? Is something as informal as an email, or does it need to be something on company letterhead?
Well, my Lord Justice Birss makes a fair point. Perhaps that the sensible thing is for you to actually issue an application for joinder. Make sure you reference CPR 19 in that application, and then that will identify the insurer. And hopefully that can be done today, and we will deal with it in our judgments.
Yep.
Thank you.
My lord, if my lady, and perhaps if I can just begin by setting out how I put this appeal.
Yes.
There's the narrow point and the wider point. And the narrow point comes down to whether the judge, in his assessment of the material facts and evaluating whether there was an abusive process, got it wrong, whether he got it wrong insofar as his reasoning as to whether the procedural rules were not being used in a way that was intended. And then there is the wider point, which concerns the cherry picking of how pre-action conduct is put by those intending to bring a claim to take advantage of the more favourable position on the recovery of costs. And from my reading of my learned friend's skeleton argument, and if I could just take you to that very briefly on the wider point, it's in the core bundle, and it is at page number 206. It's the replacement skeleton argument. And what is said at page 206 and 207 is, in my submission, at paragraph number 4 in brackets, an acknowledgement that there is a motive behind using the rules in the way that we say they have been used, and the explanation that has been given is that the regulations and the legislation permit them to do so. So I don't think there's any contention between the parties that that is the motive in so far as the way that the claim in this instance at the pre-action conduct stage was presented. But I come back to the narrow issue, and perhaps if I can start with the authorities, and if we look at the authorities bundle in the case of Actus, which was referred to by the judge below and relied upon by the judge below, at page 110 of the authorities bundle, and if I can take the court to paragraph 90, it is at letter D, where Lord Justice Ricks says, "I say a mere negligent failure to serve in time in order to distinguish the typical case of such failure to be found in these appeals and many other cases in the reports from the more serious disregard of the rules." And he goes on to say at E, however, all the cases make clear that for a matter to be an abusive process, something more than a single negligent oversight in timely service is required. The various expressions which have been used are inordinate and excusable delay, intentional and contumelious default, or at least wholesale disregard of the rules. And what we say is that where the judge has fallen into error is that this is not a case in which the abuse of process argument was run below on the basis that there was just simply a negligent failure to serve proceedings in time. It does fall within the something more category, because when one looks at the entire conduct, pre-proceedings and post-proceedings, there is a clear abuse of process.
You mean post-issue, do you?
Post-issue. Can I take you to paragraph, it's on page 98, paragraph 53 of the Actus decision. And this is in respect of how the courts approach an appeal, and I don't think there's anything that is controversial in this, that the question of whether a judge was right or wrong to find an abuse is an evaluative judgment. There's only one answer. Either it is an abuse of process or it isn't. It's not a discretionary point. The discretion only comes in insofar as the sanctions that are to be applied in the event that the court finds that there is an abuse. And so what we say in our appeal, and we've always made this clear in our appeal, is that the judge got this wrong, and he got it wrong for clear reasons, which I will come on to in a moment. Can I take you to the next authority, which is Cable? And I'm just dealing with the principles and the points first before I take you to the transcript of the judgment. And it's page number 57 of the appeal bundle. Could I invite the court to look at paragraphs 56, 57, 58, 60, and 62. The sum total of these passages make it very clear that pre-action conduct, and in this instance the pre-action protocol, is of course a central part of the architecture of the civil procedure rules. A failure to follow the pre-action protocol can result in serious sanctions. The Nelson's case, which I have cited as an example of how the court will depart from a general order or a deeming order on costs where there has been a failure to comply with the pre-action protocol. The issue here is how much reliance did the judge place on what happened before the claim was issued and how the claim was presented. And I say that because one thing that is clear is that despite the claimant's criticisms of the failure of the defendant to engage with the pre-action letters of claim that were sent, the court at first instance did not find any blame on the part of the defendant, but instead found blame on the part of the claimant. And the circuit judge who heard the first appeal, His Honour Judge Owen, likewise did not blame the defendant for not engaging in the pre-action phase for reasons which he described as being that those letters that were sent were inadequate, but a mistake. And I'm summarising what he's saying there. Perhaps I shouldn't, and I'll take you to reasons in a moment.
No, sorry, you've got a little confused there, I think. The no blame on the part of the defendant was because it was accepted that the defendant thought these were scams.
At first instance,
Yeah.
yes. That was not disturbed on appeal.
No.
And the witness statement which you've seen from Mr. Ruendal, which was based on the instructions that came from the director of the defendant company, was...
In the pre-action letters, there's reference to a letter of apology from your client. Have we ever seen that?
No, there's no evidence has been advanced in either way on that. I don't think that matter's ever been raised. The short point is that nothing was known at the pre-action stage about this claim because nothing could be identified. And I'll take you to the letters in a moment. We're still on Cable, my lord and lady. Perhaps if we can look at paragraph number 69 and paragraph 70 on page 59 of the judgment. And in cable, of course, and if I'm looking at paragraph 69 and 70, there is a repeat of the point that I've made before, which is that, paragraph 70, first sentence, the evaluation judgment as to the consequence of the appellant's solicitor's conduct was clearly open to DJ Campbell. In these two passages, the court identified what was abusive conduct. Of course, the facts are different slightly in cable because the claimant's solicitors had issued under Part A when they ought to have known that it was a claim to which Part 7 applied. And they sought to seek a stay in circumstances where they ought to have known that the proceedings should have been under Part 7. But those factors, of course, form part of the evaluative judgment. The key point here, and I'm not sure if this is being pursued in response to our appeal, and it's paragraphs 72 of cable, that there isn't the need for the party that is claiming that there has been an abusive process to have to show that there has been some manifest unfairness to that party. We would say that there has been manifest unfairness, and that manifest unfairness was found and accepted by District Judge Nicolle, who found that we had been prejudiced. That is not a finding that His Honour Judge Owen disturbed or sought to disagree with. But in order to make out the case on abuse, manifest unfairness is not the prerequisite. And going back to Actus, if I may, just very briefly, and it's in the head note at page 78, the point that is recorded as per incuriam in that head note is that sometimes when considering whether a second action should be permitted under Section 33 of the Limitation Act, the court will also consider whether there's been an abusive process. And the criticisms that we have made in our grounds of appeal is that the judge below sought to divest or to divorce the failure to serve the claim form in time from the criticisms that we've made about the pre-action conduct. And the point that we make in this appeal is that if, as a matter of law, the court would look at everything when considering abuse and Section 33, it must follow that when the court is considering whether there has been an abuse, the court should also take into account, particularly when looking at what sanctions would apply, whether the claim form was served within time. And I say that because a lesser form of sanction, which the judge on appeal said would have applied, is something that could not, on the facts of this case, have happened because this case was always doomed, this claim was always doomed by reason of the fact that the court had declined jurisdiction and it had been served out of time. And therefore, the only consequence of that would have been for the claim to have been struck out. Can I invite your lordships to just briefly consider the decision of this court in Achill, and it's page...
Point this way, forgive me. Can I just make sure I've understood the submission you just made? What it sounded like you were saying, and I don't want to put words in your mouth, was because assuming there is a finding of abuse relating to the pre-action conduct,
Yes.
and assuming the state of affairs is that the action has been struck out, which is the other thing that happened,
Yeah.
was your submission that given those two facts, the only sanction for the abuse would have been, sorry, not struck out, forgive me, assuming the abuse and assuming that the jurisdiction had been declined, you say the only sanction for the abuse which the court could ever have ordered would be to strike it out?
Yes, because the court could not, because the claim could not continue.
Right.
The court found that it had to decline jurisdiction.
Yes.
The claim could not continue and therefore no lesser sanction could have been imposed.
I understand.
with respect
Perhaps
to
the answer would have been no sanction at all.
Not in circumstances where the application was framed both under Rule 3.4 as well as jurisdictionally under Part 11. It's in the original application notice. And I make this point because learned friend says that we never applied for it to be struck out under 3.4. We did in the original application.
I think
but it was-
we're at cross purposes. Maybe I don't want to pursue it too far because maybe it isn't what you meant. But what I thought you were saying was that if you find there's been abuse, let's say in the pre-action correspondence, but also the jurisdiction has been declined, then it follows, as I understood what you said, that the only sanction that the court could order and would order would be to strike out the claim.
Yes,
And not, for example, to do nothing.
that's right.
Right.
Because the court would be driven to have to strike out that claim because that claim could not survive because the claim form wasn't served in time.
Right. Why shouldn't? Okay.
But
That's your submission. I understand.
it comes back to the point, my lord, that was made in the Cable case, and that the passages that I took this court to at the very beginning, which is the mere failure to serve by itself is not an abuse. Something more is required. We understand what is said in that judgment to be this, that a failure to serve can be an abuse if it's accompanied by something else that is more serious. And our submission is that the failure to serve in this case was accompanied by a course of conduct that was far more serious. And therefore, we do fall within that category of cases where the court will consider abuse of process. Does that answer your lordship's point before I...
I understand your submission, Mr.
Yes. Taking you back to Achill, if I may, and the judgment, of course, starts at page number 65 in the authorities bundle, and could I invite the court to look at page number 74, and it's the paragraphs that are marked up, paragraphs 30 and 31. And what the court, this court has identified in this recent decision is that Rule 44.15 is confined to those cases, and I quote from the last part of the sentence that is at the end of paragraph 30 between letters B and C. Essentially, these are claims which should not have been brought in the first place, or where the claimant's conduct of the claim merits the severe sanction of striking out. Of course, this was one of those cases for the reasons that I have already given. It was a case which, by reason of the way that it had been conducted and compounded by the failure to serve the proceedings in time, it was always doomed to be struck out. I now turn to the transcript of the judgment, and where we say that the judge fell into error.
And this was an oral judgment, was it, with a full transcript afterwards?
Yes, this is an oral judgment with a full transcript afterwards, and as I understand it, it was approved. There was some time taken before the transcript was released. It was approved by His Honour Judge Owen's.
Thank you.
And could I take the court to page number 61?
Yeah, paragraph 71.
Paragraph 71. And he says, I'm satisfied that the learned district judge was wrong to strike out the claim as an abuse of process for the stated reasons that she gave. The continuing with the claim wherein the claim form has been served out of time is an abuse. In my view, the complete answer to this is paragraph 90 of Actus. So just stopping there, his rejection of our argument that there had been an abuse of process was focused on whether the claim form had been served in time. And the view that he's taken is Actus disposes of that point. And the point that we've made before him was that we fell into that category of this is a failure to serve in time with something else. Then at page number 64, paragraphs 81 and in 83, he says, in my view, however, even having regard to the totality of the material before me, having considered the authorities that I've cited, there was, in my judgment, no proper or sufficient basis in which the court reasonably and properly find that there was an abusive process and the claim should be struck out. And he says, paragraph 83, in my judgment, stepping back, these are mistakes or errors of judgment, and this is with reference to the protocol letters that do not amount, whether taken on their own or with other features of this case, to an abusive process.
So what's wrong with 81 to 83 in terms of approach?
The approach is no one has ever said that those letters were a mistake. The evidence that was filed before the court was not that those letters were sent in mistake or that they regretted sending those letters or providing an explanation for those letters. In fact, to the contrary, the appellant, claimant below, relied on those letters as being perfectly valid letters for the reasons that this was a case which was not at first instance advanced as a personal injury case. And I'll take you to that because before we look at the letters, it's important to look at the evidence that was filed by the claimant below. And it's, again, we're in the supplementary.
All right, but just in terms of approach, so not entitled to find mistake, error of judgment?
Or error of judgment.
Right.
Because
So, but in terms of principle, so not entitled to find mistake or error of judgment, but in terms of the approach, looking at the totality of the material, including the pre-action protocol letters, nothing wrong with that.
no, there is, because he did not find that those pre-action protocol letters were satisfactory or that they complied with the protocol. He didn't make that finding. The finding that he made was that the reason why they didn't meet that protocol was because there was an error in judgment and they'd been sent in mistake. And that is contrary to the evidence that was before him and before the judge, and also contrary to what was said at first instance below. And that forms an integral part of the evaluative judgment when considering, because his reasons was if I could put it this way, he broke up the list of complaints that were made on the appeal and said the failure to serve a claim form in time would not by itself be an abusive process. And then looking at the letters in isolation, where they were sent in mistake or there were errors of judgment and that of
But you
itself.
didn't look at them in isolation. At least twice on page 64, he says, I'm looking at the totality.
Of the letters. But
No, the totality of the material, para 81 and para 83, it's the letters on their own or with the other features of the case.
yes, but he doesn't expressly make reference to them as well as the letters as well as the failure to serve in
Well, he
time.
does. He says, taken on their own or with the other features of the case, which includes the failure to serve in time and all the rest of it. Am I wrong about that?
We've understood his judgment to say something else, but even if that is what he is saying, he's still fundamentally wrong in respect of finding that those letters were sent in mistake or that there was an error in
All
judgment.
right, so the real focus of your complaint is the finding that these were mistakes or errors of judgment, and you say those were findings he was not entitled to
Yes,
make.
and the correct evaluation is that for
The
reasons...
evaluation, forgive me for interrupting, the evaluation is whether or not this is an abuse.
Yes,
Whether or not there was a mistake or an error of judgment may fall in a different category.
yes.
But anyway, you say absolutely not entitled to make the finding of mistake or error of judgment.
Well, yeah, and where I say that the error in his evaluation of this is that, in fact, these were deliberate letters that were sent as part of a wholesale disregard of the pre-action conduct and what a party is required and pre-action conduct. And I'm going to come on to that point
Okay.
in due course. And if we just start with the evidence...
Sorry, can I just stop, pause you there? You said he is fundamentally wrong to find that the letters were sent in mistake. And I had not read the judge's language as being that they were sent in mistake, but that they were mistakes. Now, those may be two different things. I mean, it's one thing you say it was a mistake to write a letter which is unreasonable because it doesn't include the name of the claimant. That's a mistake. It's not sent in mistake.
Correct.
They deliberately did that. So what is it you're saying was fundamentally wrong?
In the judge's conclusion here.
Yes.
Of
His
mistake and
conclusion
error
that,
judgment.
that what was written in those letters mistakenly or as an error of judgment. It was a deliberate decision
No, but
by the lawyers who wrote those letters to send them as they
there
were.
was deliberate error. The deliberate letters, but
Yes.
it was the wrong call. It was the wrong decision to write them in the way that they were written.
Yes,
Deliberately.
and the question that follows is, was this a forgivable error that was not abusive, or was this done as a disregard of the rules?
Right, okay.
And that is the point that I'm making, and forgive me if I've
No,
not
understood.
made that
Right, so
clear.
take us, you going to
So
take
he
us
was
to the
bound
letters?
to find that what happened was a deliberate disregard of the rules. Is that the proposition?
The proposition is that this was a disregard of the rules. If this was a claim that was advanced as a personal injury case squarely, as the judge had found it to be, then the personal injury protocol would apply. They chose not to follow the personal injury protocol. They chose instead, but they didn't follow any protocol as such when one looks at the letters. And the question is whether the judge was also right to have found that this was always a personal injury claim squarely, or whether it was being advanced to something else. And I say that because if we look at the evidence that was, and I'm taking the court now to the supplemental bundle.
Was there ever a schedule of loss and damage served?
There was a schedule of £50 miscellaneous expenses for court, for writing letters and so on. Also seem to have a bit of a computer failure at the moment.
Don't worry.
If you,
Don't panic.
can I take
Just
you?
to go to the letters of claim.
Well, before we look at that, if I could just ask you to look at the claimant's solicitor's letter, and this is the letter that's at page 211 of the. And this is the witness statement of Mr. Mayer, who was the solicitor with conduct on behalf of the claimants in opposition to our application to strike out. And at background, this is how he describes the case. He says, background 4, the claimants are pursuing a claim against the defendants for misuse of private information, breach of confidentiality, breach of the Data Protection Act on behalf of the estate of Miss Rosa Taylor, deceased. Now, I've gone through this witness statement, and there's no reference or no significant reference to this being squarely a claim for personal injury. And if we look at the...
Sorry. But it refers
He's
to the
describing
claim
the causes of action, not the damage.
He's describing the causes of action. He doesn't make mention of any personal injury.
He's accurately describing the causes of action.
He's describing the causes of action indeed, but not that this is a claim for personal
But
injury.
he refers in paragraph 18 to all the correspondence.
Yes.
And if you look at the letters, they all refer to personal injury.
Can I just look at the first letter, because there's something called an initial letter of claim that was sent, and that's at page 226.
Yes.
And there's no mention of personal injury in this letter. This is the first.
That's the first one, correct.
The first one.
Yep.
There's a chaser letter, of course, which is merely a chaser letter. And then we have the further chaser letter at page number, or email at page 232, which refers to data breach.
Hold on. Yes.
And then we have at page 235, again, reference to distress and other losses arising out of the misuse of personal data. Nothing about an injury as such. And what is of note at page 235 is they've said that they've entered into a conditional fee agreement with their client, which provides the recovery of a success fee. Then we look at page number, these are exhibited to the claimant's solicitor's witness statement, page number 237, which has no reference to personal injury. And then, of course, we've got the letter of claim, which is the pre-action letter of claim on the 17th of October 2018, where reference to personal injury, such as it is found at the very end on page 243. And all that is said is that she suffered distress, a loss of control over private information, and mental health difficulties. And the injury and distress section simply says that we're also instructed that the claimant's mental health has been affected by these breaches, and they say they're instructed to pursue a claim for personal injury. Now, at this point, in my submission, that is not a materialized claim for personal injury. And the way that I'm going to invite this court to consider the submission that I'm making is by looking at it through the prism of the hypothetical litigant that gets these letters, that goes to a high street solicitor and asks the high street solicitor, what is it that I'm being sued for? And in my submission, on an objective analysis, where the pre-action letter of claim does not say that it's being sent under the pre-action protocol for personal injury claims, where it doesn't, in the usual way for personal injury claims, invite the other side to consider the nomination of experts and to be instructed for the purposes of preparing a report and so on. Anyone looking at this case would consider that this was a claim for privacy, data loss, in which damages are for the claim that for loss of control and distress, and at best that they're also instructed to pursue a claim for personal injury, but it stops there. And I say that because if the argument is put, well, we didn't know that it was a personal injury claim at that point in time, bear in mind that this claim was, this pre-action letter of claim, which is the last pre-action letter of claim that was sent, and it's on the 17th of October 2019. I've made the point in the replacement skeleton argument in answer to Malone and Friend's point that the media and communications protocol was already in existence and had been in existence at this point. It is still nevertheless sent in excess of 2 years before this claim is started. So there is ample time to comply with pre-action conduct, pre-action protocols, and to serve the correct pre-action letter. And I say that because I want to just highlight the chronology here in this, because this letter was sent it was sent in October of 2019. And if we go back to the core bundle, we can see that the doctor who was instructed to prepare a report for the claims, and it's page number 120 of the core bundle. This is the medical report that was filed with these proceedings. Refers at point number 2 under the heading sources used in the preparation of this report that he had an interview with the claimant on the 6th of...
Sorry, page?
Page 120, 120 of the core bundle. And it's the medical report of Dr. Medley. And if the court would be, just look up at page 119, we can see the report is dated the 23rd of May 2020.
So it's my fault, it's completely my fault. Supplemental bundle?
Core bundle.
Core bundle 120.
Core bundle.
Thank you.
Core bundle, page 120
Thank you.
and page 119. the first 2 pages of the medical report of Dr. Medley. And the report is dated May 2020. Now, this is well over a year before proceedings were issued. It refers to an interview with a client on the 6th of April. And if one scrolls down in this report at Your Lordships, and my lady gives me one moment, it's page 126. The instructions that they gave were that Mrs. Taylor told Dr. Medley that she felt angry by the disclosure. She made her think about the offences, and she says in paragraph 3, or he records in paragraph 3, that she consulted her GP in the August of 2018, who prescribed medication, which she took for about a month. And the point that I make about this is that clearly the claimant's instructions at that stage is that this was a personal injury case. Any solicitor would have known that there is a claim for personal injury, and therefore the correct protocol would be the personal injury protocol to follow.
Can I just understand what you mean by at this stage? You said clearly the claimant's instructions at that stage were that this was a PI case. So you're referring to August of 2018, or the time when the report was
Well,
produced?
I would submit that one can deduce from that the claimant's instructions that she sought medical attention in August 2018, immediately afterwards, would have been known, or ought to have been known, certainly at the time when that letter on the 17th of October was sent, because they were instructed to pursue a claim for personal injury. And undoubtedly they would have taken instructions from the claimant. Now, we don't know what the conversation was, but clearly there was sufficient information that had been given to them to write in that letter that they were intending to pursue a claim for personal injury. So the decision that personal injury would be pursued must have, by the very latest, have been crystallised by October of 2019. And that is still well before these proceedings started. Sufficient time to pursue this claim under the correct protocol, rather than a protocol. Well, there was no protocol that was followed. I think that is correct, and I don't think anyone has found that they had followed a protocol that they were entitled to.
Well, they were referring to the requirements about pre-action conduct rather than any particular protocol.
Well, they were, yes. Well, they made selective reference to pre-action conduct. But if this is a claim for personal injury, if it's squarely a claim for personal injury, then of course the personal injury protocol would apply. Yeah. And I say that because not only were the instructions clear at by the latest that stage, I think there's reference to a letter that was sent, which is the same letter as the one that we saw on the 17th of October, that was sent actually in February of 2019. That's attached to the witness statement of the defendant, or it may be Mr. Roundell. I'll give you the reference in a moment. But nevertheless, it's a mirror copy of that 17th of October 2019 letter. So clearly, earlier on that year, they would have known about the claim for personal injury, and therefore plenty of time to comply with what is required. But we look at what...
Forgive me, Mr. Wade.
Yes.
Can I just unpack that slightly? When you say to comply with what is required, as I understand it, one of the main points, maybe the main point about the PI protocol, the personal injury protocol that you're referring to that didn't happen, is relating to experts, getting that expert aspect.
Amongst other things. Yeah. Amongst other things, it's a statement of the circumstances of what has happened. I don't think there's any, I submit that there is no argument that those letters were woefully inadequate in terms of what they said. Nobody has sought to justify them, save for the claimant solicitors in the witness statement when they placed reliance on it. And I've already made the point that the judge was wrong to say that they were sent in mistake, or that they were written mistakenly, or an error of judgment. But could I just look at this from another perspective, because the question of whether quox applies, if it's said that this is perhaps a mixed claim, it's not been found to be a mixed claim. His Honour Judge Owens didn't find it to be a mixed claim. But the remedies, and I say this because the point that is made by the claimant in response to our argument is that what is important for the selection of the correct protocol is the cause of action that's being pursued rather than the remedy that is sought. And I say that that's not correct because on the correct reading of the pre-action protocol for personal injury, it's where personal injury, it forms part of the claim, even if it is a minor part of the claim. Now, the protocol has been revised to take account of the intermediate track now, but it's still, the protocol that was in place at the time on those material points was still the same insofar as claims that would normally fall into the fast track. And there is no dispute on this case that it would have fallen into the fast track. His Honour Judge Owen certainly took that view. And if you need a reference to that point, I can take you to it. But he says, and I will find it in a moment, that it would have been in any event a case, because it was limited to £5,000, that would have been allocated to the fast track. But we look at what the state of the law was at that stage, and perhaps if we can just look back at the authorities bundle for one moment, and can I take the court to the decision in Jeffreys, which starts at page 15 in the authorities bundle. And the passages that I have highlighted in Jeffreys, paragraphs 34, page 23, my lady.
Thank you.
And it's at C. This is where the judge, and Jeffreys has, I think, been adopted and accepted as good law by the Court of Appeal in Brown. But the decision of Mr. Justice Morris, when he looks at the question of proceedings, and if we look further down over leaf on the next page, the top of page 24, it says, secondly, that even if proceedings in the Rule 4413 were to be read as reference to claims or a claim were to be read as proceedings, then since CPR Rule 4413 addresses claims which include, for example, personal injury claims, read literally a claim or proceedings which included not just personal injury, but also non-personal injury claims would still be a claim for proceedings to which this section applies. And it's this point that's been made about whether one has to look at divisible claims or indivisible claims. The point that is made here and has been accepted and applied in subsequent decisions is that where you have a claim which includes a claim for personal injury, qualified one-way cost shifting applies. It's a PI claim. Unless at the end of the case, and this comes back to Akil, because in Akil, 4415 is considered where a case doesn't get off the ground, and 4416, which is the provision to make an order in which part of the costs are enforceable, kicks in at the end of the case when the court looks at whether these are mixed claims. So the point that I make here is that certainly before these proceedings were issued, before these letters of claim were sent, the law was, and was presumably known, or ought to have been known by those who were representing the claimant, that qualified one-way cost shifting would apply if the claim contained a claim for personal injury. And I don't put it too highly, I submit I don't put it too highly, when I say that the claim for personal injury was soft-pedalled. It was tucked away at the end of the pre-action letters of claim, and applying the analysis that I indicated beforehand, which is what would a high street solicitor looking at this be advising his client? Is this a claim that's being brought for personal injury or not? The answer to that is it would not appear to be the case.
What are the reasons why the client would care about the categorisation of the claim rather than how much he was in for?
Because it affects his cost position.
Yeah.
Of course, the fact that you cannot recover, you cannot enforce an order for costs if you are successful as a defendant would affect how a client, a litigant will consider and would certainly
But
affect
it
the
really
advice.
would affect the advice that he gets from that.
It was indeed.
He wouldn't know any of that. You wouldn't
No,
expect him to know about quocks or how the cost regime for success fees operates.
Yes, and my lord, that
So it's the expert looking at the letter.
yes,
we should be considering, not the layperson.
yes. In the example that I give, my lord, it's the hypothetical litigant that goes to a high street solicitor, and what would he be advised?
Yeah.
Yeah. And of course, that is as much relevant to a hypothetical litigant as it is to a hypothetical
Yes,
insurer.
obviously the cost position is very important,
Indeed.
especially in these low value cases.
Indeed. And it affects decisions on whether settlements are to be, offers of settlements are to be made, and it is for that reason I submit that the rules and the reason why pre-action conduct requires parties to be setting out in clear terms their position in the pre-action correspondence, because it ultimately does affect decisions that are taken when these claims are notified as by way of a pre-action letter of claim. It is as important at the start of before a case is issued as it is after a case is issued.
So where are we on attacking paragraph 83 of the judgment?
So where we are is we come back to what the judge, and I'll just come back to the core judgment. If you just bear with me one moment, my lady, whilst my computer tries to...
So this is the attack on the finding of mistake or error of judgment. So
Yes.
through the pre-action correspondence, and you say should have been compliance with personal injury protocol if this was a personal injury claim, personal injury deliberately soft-pedalled,
Yes.
and therefore not just mistakes or errors of judgment.
Yes. Because what the judge goes on to say in his judgment is that, and if we look at paragraphs 77, 78, this is when he discussed whether it should be struck out. The point that the judge made was that it was always clear that this was a personal injury claim. The expression that he used was that it was squarely a personal injury claim. And he's wrong on that, because for the reasons that I have just argued before this court, this claim was not being presented as a squarely personal injury claim that was being advanced under the correct protocol. And that is another factor that, in my submission, he did not approach properly or address properly or reach the wrong conclusion when considering whether there has been an abuse. The reason, and this is in answer to my Lord's point that's been made about the importance of knowing where one stands, it's the salutary message that is said, that is recorded in the judgment on Brown, which is in the skeleton argument. I can take you to the correct passage in the judgment. It's in the authorities bundle at page number 44, and it comes from what Mr. Justice Foskett said in an earlier case of Sadiq. Forgive me, it's at page number 45, paragraph 58, about how the court has to be cautious that the tacking on of a claim for personal injuries, which doesn't really have much merit or is weak, may be designed in order to invoke quox protection.
But just standing back of where we are, you refer to the authority which says a single act of negligence isn't abuse, and that's fine. So there may be cases where multiple negligent acts are so repeated, so serious, of such a nature that cumulatively then can amount to an abuse. But two pieces of negligence may not. It depends on all the circumstances and so on and so forth. But was it ever part of your case that the failure to follow the personal injury protocol was deliberate, in the sense of, obviously the letters were written deliberately, but you say there was a conscious decision not to use the personal injury protocol, even though this was a personal injury claim?
Yes, well, that was the argument before the judge below. We said he dismissed my submissions. The reasons I've taken the court to, he dismissed them on the basis that they were mistaken and in error. And my submission on that point has been...
Well, take me to that bit of the judgment. So you say that he should have found there was a deliberate decision by your lawyers not to use the correct protocol.
That's right. That's what that is the complaint that I make.
So more than just a deliberate decision to write those letters, which were, as a matter of fact, failures to follow the right protocol, a conscious decision specifically to depart from what the PAT required in a PI claim.
And the rules on costs that would apply. And I say that because the letters speak for themselves on that. And if
just where in the judgment does he record this submission, your submission, the learned judge below? Or if he doesn't record it, where do we find it in your skeleton below?
Can I in my skeleton?
Yes.
It is under...
Whilst we're looking at it,
yes.
Just, I asked you a question about the schedule of loss.
Yes.
Interestingly, or not, I found the counter schedule at page 171.
That's in the second proceedings, I believe, it's been issued.
Right.
These no defence has ever been filed in these proceedings.
Of course. Okay, so that's seconds. Yes, ignore me. Yep.
Can I come back to you, my lady, on that? There's quite a few things have been thrown at me to try and juggle at the same time. I will give you where it was complained of.
I mean, the summary of your argument is in paragraph 76 of the judgment below.
Yes.
Which doesn't record you saying that this was an abuse in the sense that it was a deliberate decision not to comply with an applicable protocol. But you may have said that. It doesn't record it, as far as I can see.
The complaint was certainly made about the pre-action conduct in the skeleton argument, and I am quite sure, even though I can't take you immediately to where it says so in the transcript, that we had this argument below. I think the point that was being run at that time was that we shouldn't be, the question of abuse was not open to the court because having decided that it had no jurisdiction, you could not abuse the process. That was an argument that was rejected, and as for the reasons, when one looks again at the judgment of His Honour Judge Owen, he permitted the parties to argue the point in more detail. Given that it was abuse was dealt with very briefly at the end of a lengthy hearing, a lengthy remote hearing before the district judge. My lady, I'm just looking at. To
be fair, paragraph 75 also refers to summarises parts of your judgment.
Well, I'm grateful, my lord.
Your argument. Well, my lady is to be thanked for that.
Yes, I'm grateful to my lady as well. Can I just come back to, of course,
Yes.
this point, because before, and I don't want to lose this thought, it is important. And if we look back at the letter that was sent on supplemental bundle, page 240, it's the pre-action letter of claim. And this is why I say it must be deliberate, because if you have a claim for personal injury, the law says Quox applies. That had been the law since 2018. This letter is sent in October of 2019. And under funding, on page 243, what is said is, again, they have entered into a conditional fee agreement with their client in relation to the claim. And they say the claimant has not yet taken out a policy of after-event legal expense insurance. I believe the policy has been taken out subsequently, but reserves the right to do so. We consider that the additional liabilities, namely the success fee, and if appropriate, the costs of the ATE policy will be recoverable from you at conclusion of the claim. So going back to the hypothetical situation in which a litigant goes to their high street solicitor, the advice that would be given is that what is being said is that this is a case to which qualified one-way cost shifting does not apply. It's
That can't be right. Look at the next paragraph. However, in the event that we consider that a claim for personal injury is appropriate, then the qualified one-way cost shifting...
But that's exactly my point, my lord, that if it's appropriate, there hasn't been advanced as a claim for personal injury, and they would have known it was a claim for personal injury at that stage. And they would have known that if you include a claim for personal injury, qualified one-way cost shifting applies.
Well, they clearly do know that because they're setting it out in terms in that paragraph.
Yes, but the question is
Your point, I think, sorry to cut across, is that the personal injury claim was being presented, as it were, contingently, it's in the event that a personal injury claim is appropriate. We are instructed to, but we have yet confirmed that we are.
Yeah.
Well, I mean, you can read lots of this either way, but that, you say that's an important paragraph.
That is an important paragraph, and just following on from that correspondence, and it's page number 248, and this is the 31st of December 2020, so this is 7 months after the report of Dr. Medley, in which they refer to the initial notification of claim that was sent. We looked at that a moment ago. The 17th of October 2019, we contacted your offices requesting a secure email for the pre-action letter of claim, or the letter of claim as they describe it. And even though clearly they were intending to pursue a claim for personal injury, because they had obtained a medical report and a favourable medical report at that, this was still not being presented as a claim for personal injury, and no attempt to comply with the protocol.
And sorry to just, I think I mentioned this before, and so forgive me for being obsessed by it, but the point is that under the pre-action protocol for personal injury claims, you don't instruct an expert in that way. You discuss it with your opponent.
Indeed. But
That's one of the whole points of that pre-action protocol is
yes,
not to do what you say happened in this case.
But that's part of it. But the important part in the analysis here of the matters that are being complained of is that Quox was invoked only at the end of a hearing when they sought to rely on qualified one-way cost shifting when the claim was struck out. The evidence that was filed in opposition to our application made no reference to Quox or the position on costs or anything along those lines. It was described by its causes of action, and qualified one-way cost shifting was called in at that point. And the point that I am making is that it can't be a mistake or an error of judgment not to describe this as a personal injury claim or not to follow the pre-action protocol for personal injury. Because certainly by the time that letter was sent, clearly they were intending to pursue a claim of personal injury. And the importance on that rests on those two paragraphs that the court was taken to a few moments ago, one of which, of course, the Lords pointed out, is that they may be seeking 100% success fee to recover from in the event of success, or they may be invoking qualified one-way cost shifting. And the last letter, which is at page 252, is sent on the 24th of May 2021. That refers to the letter of the 17th of October again. Again, nothing is disclosed as this is a personal injury claim. So it comes as a surprise, of course, when the claim for personal injury is issued and served. But going back to really what the nub of this appeal is, it is that the judge was wrong in my submission to have found that these were mistake or error when no explanation of that kind was provided. The point that is made in response to this argument in this appeal before this court is, well, the claimants were not put on notice of that, and respectfully, that is wrong, because the evidence that was filed before the district judge, and this was filed some 3 months before the hearing took place before the district judge, and it's the supplemental bundle at page 258, and it's the witness statement of Mr. Ruendahl, makes express criticism of the pre-action conduct at paragraphs 10 and 11. And in fact, in his transcript of judgment, back to the core bundle, His Honour Judge Owen permits the argument on abuse of process, and it's page number 61, bottom of page 60, paragraph 68, permitting the appellants to raise this matter does not, in my judgment, necessitate the respondent leading any new evidence. The argument is to address a point which the respondent put in issue, that the claim should be struck out as being an abuse of process. The respondent had put before the court significant amounts of evidence about the appellant's pre-action conduct. If I permit this matter to be argued, the hearing below would, in my judgment, not have been conducted differently with respect to the evidence. And then he says, of course, in second sentence, I make no criticism of any of the participants in first instance hearing for the way in which the issue was approached.
So you're saying we had a debate between yourself and my Lord Justice Warby about what is meant by mistake or error of judgment. Assume that the judge was not saying that it was just a mere oversight, that it was a deliberate decision. You say if it was a deliberate decision to write these letters in defiance of the personal injury protocol, that could not be categorised as an error of judgment. That has to be abusive. That's what you said.
Because it's a disregard, a wholesale disregard of what is expected as part of pre-action conduct. And the law is sufficiently clear by this stage that if you are bringing a claim for personal injury, even if you may have other causes of action and you're seeking other redress, such as damages under the Data Protection Act for distress or non-material damage, qualified
a deliberate decision to ignore, to flout the personal injury protocol in order to secure the most advantageous costs outcome.
Yes. And this isn't a theoretical matter, my lady. It's real, because the Rain case, in which permission was granted by Mr. Justice Turner to appeal, happened to be a case in which, again, there was disclosure of personal details by a former employer to a third-party rogue. The appeal is proceeding on the basis that the decision below to impose liability was in error. However, on the question of costs, the court acceded to the argument that because this claim was brought under the exempted causes of action, the claimants were entitled to recover 100% success fee. And that is, and I'll give the court the reference to that, that is in the supplemental bundle.
I think we should just perhaps lodge a note of caution. The decision is under appeal, is that right?
It is under appeal.
First instance decision. What level of judge was it in Rainey?
It was a recorder.
Recorder. Are we really going to be assisted in our deliberations today by consideration of any of the papers in Rainey?
You are insofar as it makes the point that this cherry picking to take advantage of the most favourable funding arrangement is not a theoretical mischief. It is a real mischief.
Well, is reference to one other case going to make that good? I mean, I think we can take it on advice that this sort of activity may happen.
It forms part of our appeal, and I make reference to it because Lady Justice Nicolle Davis, of course, referred to that in the reasons that she gave for granting us permission, and that's why I refer to it. But if the court is prepared to accept that it does go on, then we don't need to look at it any further. The point that I make is that because it has been broadly accepted in Mr. Whibley's replacement skeleton argument that he says the rules permit them to do that, that is the purpose of formulating the claims in the way that they do. And I submit that the only one party in a situation where you get to recover a 100% success fee if you're successful, and you avail yourself of Quox protection if you're unsuccessful, the only one party that really benefits from that, of course, is the legal advisors. Because
if the rules permit you, as is said against you, to ride, if the rules are created, the protocol, the cost rules are designed so that you can actually have both possible outcomes, is the mischief at which you should be tilting the... If what is a claimant supposed to do in that situation? Comply with both protocols. The media protocol wasn't in existence, so here...
It was when
sorry?
It was when the letter on the 17th was sent.
Right, okay. So is a claimant who has the potential of both outcomes, it is then obliged to follow both protocols? Two protocols are engaged.
No, my lady, the only protocol that would have applied would have been personal injury, because it was a claim for personal injury. If the judge is right in saying this was squarely a claim for personal injury, then only one protocol would apply, and that would be the claim for personal injury.
And what's the basis for that submission?
The application of qualified one-way cost shifting from the Jeffreys case that I referred to.
No. Why is it only that protocol? You're mixing up the application of Quox under the rules and the application of a protocol, and those are two separate things.
My lord, the protocol, I believe, and I will open my copy of the White Book up, I believe the protocol says that if there is a claim, includes a claim for personal injury, it's not dependent on the cause of action, it's the remedy that's sought, then the pre-action protocol for personal injury would apply.
Well, we agree on that, but the point is different. The protocol you use doesn't necessarily determine the costs outcome. It seems to me that somebody, if Mr. Whibley is right, and that there are two options here, and the rules allow you to, you would say, ride both horses at the same time, then is the answer that what the claimant in this situation should do is comply with both protocols. And therefore, your target perhaps is not so much the riding of both, could be not so much the riding of both horses as the failure to follow the personal injury protocol.
Well, there comes a point when the claimant decides what is this claim.
Well, why can the claim not be both?
Because in my submission, that the way that the point has been argued by the claimant below and on appeal is been seeking to have their cake and eat it. And I say this for this reason, because when one looks at Mr. Whibley's skeleton argument, his replacement skeleton argument, at page number 199 in the core bundle, he says these proceedings were a claim for personal injury, which aligns himself with the judge's findings that this was always a claim for personal injury.
Well, the judge didn't actually say that. But anyway.
Well, there was, I think he used the word squarely.
Is now. He said whatever may have been said about the pre-action conduct,
Yes.
the claim as pleaded
Yes.
was squarely a claim for personal injury. That's what he
Yes.
said. Not that it was always a claim for personal injury. So he
Well-
had regard to the pre-action correspondence. But I don't want to divert you from
No, Lord's absolutely right. I don't think he expressed any opinion on the pre-action correspondence other than it was a mistake and an error. He doesn't go on to look at it and decide whether it should have followed one protocol over and above another.
I need to make sure that you have time to finish
Yes.
before lunch, but can I just ask you this? If you are wrong and the claimant is entitled to have their cake and eat it, as you would put it, is that the end of your case on abuse, or are you still left with a case which says you're entitled to have your cake and eat it, but here there was an abuse because in addition to the failure to serve, there was a deliberate decision to flout the personal injury protocol?
Yes, and the way that I've been putting my argument, and forgive me if it's not been made clear enough, is that if this was always a claim for personal injury, as is described in the replacement skeleton argument, not it could have been one or it could have been the other, then clearly there was one protocol to follow. The riding of the two horses, or the decision to present it in a different form so as to take advantage of the funding arrangements, is a misuse of what the rules on pre-action conduct are designed for. They're not designed for parties to look at how they can take full advantage of cost rules. They are designed for parties to follow a course of conduct which enables both sides to know where they stand at the earliest possible point.
No, it's designed to avoid proceedings altogether.
And to avoid proceedings altogether if proceedings can be avoided. And the point that I make is, of course, that there is an unfairness on the other side, because the other side, an integral part of knowing where he stands at the pre-action stage is knowing where he stands in terms of any cost liability that he may be faced with. Will he have to pay 100% success fee, or is this a case to which Quox applies? I know of no authority that says that you can have both Quox and recover the 100% success fee. My submission, it would be riding a coach and horses through what the Jackson reforms intended. That is the wider point that concerns the way that this case has been advanced at the pre-action stage. And in my submissions, that's demonstrably clear from the correspondence from the points that are made in that correspondence. It was not a mistake on their part. On the wider point of principle, I will give you the reference because I'm conscious of the time. Milady, it's at the Rain judgment, and it's the only part that I invite the court to look at, is at pages 89 to 91 in the supplemental bundle. And in that case, a misuse of private information was found by the judge, who awarded personal injury damages and the entitlement to recover 100% success fee, and he described it effectively as a claim for personal injury. The cases which I've not included in the authorities bundle because they're decisions of the High Court, but are referred to as by way of background and context, and those are the cases of Cleary and Marston, and also Johnson and Eastlight, are there effectively to make the point that where you have privacy claims that are being advanced in the High Court and they're of low value, they're to be sent back to either the small claims or the fast track in the County Court. And it's an example of how the court looks at the substance rather than what the cause of action is.
Well, no, that's actually an application of the CPR, which were widely misconstrued to mean that any claim advancing those causes of action had to be brought in the High Court, regardless of its value, and that was just wrong.
Yes.
Now, whether that was deliberately done or otherwise doesn't really matter. It was just wrong. Don't think that can be easily carried over into the current situation, where your point is not really to do with getting High Court costs. It's getting the advantage of the success fee regime.
Yes.
And I think your submission has to be that if a claim is for personal injury damages, you cannot take advantage of the success fee regime, whatever cause of action you're advancing in order to recover those personal injury damages.
If you are availing yourself of qualified one-way cost shifting, in which the recovery of the success fee was removed and the quid pro quo is that the order for costs of an unsuccessful defendant, of a successful defendant cannot be enforced against the claimant, and your claim is a claim for personal injury to which qualified one-way cost shifting regime would apply, and you say this is a claim for personal injury, then it is that. To use that often cited metaphor of if it sounds like a duck and walks like a duck, it is a duck. I mean, it's the way that this has been advanced to say this has always been a personal injury claim, when clearly on the at the pre-action stage it wasn't, is a very important point in the evaluation of whether there has been abuse. And what I'm saying is that the judge was not only wrong in his conclusion on the correspondence, but to not look at the bigger picture as to what was said and why it was said. And one cannot simply reach the conclusion, even when the claimant's solicitors were not saying it was a mistake, to say, oh, it was a mistake, it was mistakenly written, or there was an error of judgment in so many letters. In my submission, on an objective analysis, it was a concerted effort by the claimant's solicitors to take a full advantage of a funding position. And I say that because, as I've already made the point, they knew full well they were pursuing a claim for personal injury when they had medical evidence which was well over a year before these proceedings were started. And their continued correspondence made no reference to that, or that the claim would be a claim for personal injury. Can I just deal briefly, before I sit down, with points that were raised by my learned friend in opposition to this appeal? Because, as I understand what is said in Mr. Wibberley's replacement skeleton argument, and also in his appellant's notice, is that it was not open to us to take this point at all, because that point wasn't argued before District Judge Nicolle. And when one is dealing with something as serious in terms of its consequences as a strikeout, to use his expression, the jurisdictional threshold is a high one insofar as whether the court permits argument on that. I'm going to just invite the court to look at the way that it was formulated below. The application, which is before the court in the supplemental bundle, and it is at page number supplemental bundle, page number 148. Struck out under 3.4 is cited in the application. I again make the point that at no stage was quox being invoked at that stage. You've already seen from passing reference by the judge in his transcript that he didn't blame the parties for having argued the point as they did below. This court's already seen the reference in his judgment as to why he's given reasons for the point to be argued. But there is...
Sorry, Mr. Waite, the bit you've just referred us to, struck out, doesn't actually say struck out under 3.4, it says struck out for late delivery.
Late service. Oh, we get
Service,
late
right.
service pursuant to 3.4.
Late service.
But 3.4 was raised, and the point that's made that's being made is you applied to challenge jurisdiction under Part 11 when we also cited 3.4 for different reasons. The late service can, for the reasons that I've already argued before this court, and in line with the decision of actus, can amount to an abuse of process if it's accompanied by some other compelling reason, such as a wholesale disregard of the rules. But the very thing that they argue and they criticise us for and criticise the judge for permitting, in my submission, is the very thing that they are seeking to argue in this appeal. Because the abuse point that was run below by the claimants was that if the proceedings were effectively, to use Mr. Wibberley's language, a nullity, there could be no abuse argument. That's a very different point to the point that is being made by him in this appeal, which is that there was no abuse when one looks at the conduct. I also make passing reference to Singh and the relevant passages in Singh which are cited as reasons why the decision below should not have entertained the abuse argument. If I could just take the court very briefly to Singh, and it is page number 118 of the authorities bundle. That's where Lord Justice Haddon Cave sets out the principles about the new point not being raised where it would necessitate new evidence and should have been run below. That's already been dealt with by the judge. We don't criticise the judge for those reasons. We rely on them, and he was right in permitting the point to be argued. And on the question of whether it's a pure point of law, the three criteria that need to be satisfied is that the other party has had adequate time to deal with the point, the other party has not acted to his detriment on the faith of an earlier omission to the case, and the other party can adequately be protected in costs. And the point that I make on that is that the claimants had more than enough time to deal with this point. Their argument that they couldn't provide an explanation in time is simply not correct, because the witness statement of Mr. Ruandal preceded the hearing of the application by several months. There was ample time to address the point about pre-action conduct in a witness statement to explain why their case was run in the way that it was. There is no reliance on any omission on the part of the claimants, or at least none that I've seen being advanced, and costs only come into it if a point is something that should and could have been run below. And the judge, for the right reasons, said he was prepared to entertain that point as part of the appeal. Then we finish by looking at the other points that are made about whether it's a high jurisdictional threshold, in other words, to take a point on 3.4, an abusive process. Well, the claim was always going to die a death. The appeal against the decision to effectively dismiss it was unsuccessful. Whether it's an abusive process or not only becomes relevant, of course, in this context to the question of the application of Rule 44.15, and Quox was only ever invoked at the end of the first hearing. It was not something that the appellant was put on notice or the defendant was put on notice beforehand. I've been on my feet for long enough. You've heard my arguments. Are there any matters that I can assist the court with?
Yes, help me with this, and then I'll
It may
hand
be a
over
matter
to my
if
lord.
it's-
There
if
is,
I'm-
yes.
yes.
Are you pursuing the argument that even if you're wrong about abusive process, it was wrong to award 100% of costs?
Yes.
You
Yeah.
are.
There's not much that needs to be argued on that because the substance of the appeal below was on a point about whether the court should have struck out or dismissed the claim. That was a point that grounds 1 to, I think, 3 of the appeal were unsuccessful. The only part of the appeal was successful insofar as the reversal of the district judge's decision to find that this was a case that fell under 44.15. And the substance of their appeal was on a different point. And we argued this point, and we invited the court to consider the case law. We invited the court also to consider the proposition that because of the infelicitous timing of this defence, it being caught, of course, before the rule change following Owen and Adelaide, that we have this decision, or this position where the successful defendant who has done nothing wrong and succeeded in getting a case struck out has an order for costs that's not enforceable, yet has to pay the costs on a failed appeal that was successful only on one ground. And that is, that when one stands back and looks at the wider justice of that.
But is it simply a question of wider justice in the sense that if your points, the points you make about conduct, don't reach the threshold for abuse, are they still relevant to the costs order?
They are still relevant because much of the argument that was taken up below was whether there was a claim to strike out. This was the appeal that was being run by the claimants. They were saying that you could only strike out an order, you couldn't strike out a act that was taken by a party. Now we know that that's not correct, and the judge was against them on that point. But nevertheless, much of the appeal and the cost that would have been generated would...
And obviously there's a very high threshold for interfering what is a discretionary exercise of judgment on costs.
Yes.
But I'm not hearing from you that the, what you say, obviously abusive pre-action protocol correspondence, but you're not suggesting, are you, that correspondence failures in the context of that conduct are relevant to the separate question of discretion as to whether to award 100% of costs?
Well, it is a factor to be taken into
Yes,
account.
parties' conduct, both
Yes.
before and after the proceedings have been issued, are
Yes.
a relevant factor under the CPR.
Yes.
Do you say that these matters could come in at that stage?
But they could come in at that stage if the court takes the view that the justice of the situation is best to put them in that stage. They were certainly live before the judge, and the arguments that were run by the judge included their conduct and questions of success.
Just one thing, you've promised us, I think, you'll schedule an argument for the hearing before the judge. It would be helpful to
Yes.
have that, just so that we can see how the matter was put in relation to the pre-action.
Yes, and what I will also do, my lord, is whilst you hear from Mr. Wibberley, is to find those passages where the argument was run in the transcript, so you have those as well.
Oh, thank you.
But it would be in the supplemental bundle, and it's at... is in the core bundle. I'm gratefully assisted by Mr. Wibberley. Check that. Yes, it's at page number 76
Of which?
of the core bundle, my lord.
Thank you.
And the abusive process is at page 79 onwards to page 83. Lord, just of note, the authorities that I've referred to, Cable and Actus, the passages and so on are all cited in that skeleton argument. So that there is nothing new, so to speak, that's been raised in this that wasn't raised below.
Thank you. Thank you very much indeed, Mr. Waite. Yes, Mr. Wibberley.
Thank you, my lady, my lords. I intend to divide my submissions into 5 sections. I want to first of all address the relevant Quox rules. Secondly, I want to look at how the case was run below by the defendant, and I say below meaning both at first instance and on the first appeal. Partly, of course, because one of the reasons we say in our additional or different grounds is that the judge immediately below His Honour Judge Owen was wrong to allow the abuse arguments to be broadened over and above those run at first instance. And in fact, at first instance, they were only run as an afterthought. I then want to address the cherry-picking argument that's being put forwards. I'm mindful of setting out headings for my arguments and descending into them, but I wanted to put down a marker if I can, because I think it's important and it will be a recurring theme. And the marker is this. The application of Quox is determined by the head of loss or damage claimed. The recoverability of a success fee and an ATE premium is determined by the cause of action on which a claimant succeeds. And of course, if they advance the cause of action and they don't succeed on it, then there's no question of them recovering the success fee or the ATE premium. But I make that point because various equine analogies have been used, whether it's a Trojan horse or riding 2 horses. But what we actually have in this case is a Venn diagram. We have 2 circles, one of which is the cause of action, one of which is the head of loss. And there are a small number of cases, and it is a small number bearing in mind that the rules in relation to success fees for this sort of case were amended in 2019. We have a small number of cases that sit at the intersection between those 2 circles. If we're using an equine analogy, it is one horse that is sitting or standing between 2 paddocks. So the suggestion that there is some sort of cherry picking or some sort of abuse here is simply wrong and is based on a misunderstanding of a cause of action on one hand and a head of loss on the other. The 4th topic I want to address is how the claim was presented pre-issue. I will address that insofar as I can, and I make the point of insofar as I can because I accept that there are features of the pre-issue presentation that are not explained in the evidence, but of course that goes back to my second point, which is that's because of the way in which this case has evolved. Finally, and insofar as I've not picked them up, I want to just cover the grounds of appeal, and as part of doing that, I'll look at the additional or different grounds. Starting then with the Quox rules themselves, I'm afraid they're not in the authorities bundle. I don't know if your ladyship has a copy of the white book or is simply content to take it from me, that in terms of how they are framed, it's 44.13 which frames the scope of Quox. This section applies to proceedings which include a claim for damages, A, for personal injuries, and then you have B, and then you have C. A, it's the head of loss. B and C, it's based on a cause of action. And insofar as I need authority for that proposition, it was actually considered by this court in the Brown and Commissioner of Police case, which is in the authorities bundle. and it's page 42 of that bundle, and paragraph 46 of the judgment, where Lord Justice Coulson drew the distinction between a head of loss and cause of action. So that's the basic scope of quox then. And then if one looks at the exceptions to quox, they are at 44.15. So these are the automatic exceptions to quox. There are, of course, other protections for available for defendants, for example, in the case of mixed claims, or there are the discretionary grounds for disapplying them. But these are the automatic exceptions. So it is that the claim has been struck out on the grounds that, and then you have the claimant has disclosed no reasonable grounds for bringing the proceedings are an abuse of process, or the conduct of the claimant or some other party is likely to obstruct the just disposal of the proceedings. Our point there being, it's not simply a strikeout, it's strikeout on the grounds that, so there is effectively a causative requirement that one of A, B and C is the cause of the strikeout. This, to a certain extent, was explored in argument earlier, and the question was effectively asked, is it enough to say, well, there is a technical reason for strikeout and there is some abuse, ergo quox do not apply? And we say, as a matter of ordinary English language, that must be wrong. Quox can only be disapplied if the reason for the strikeout is one of the specified factors. And fundamentally, that is one of the problems in this case, that the defendant sought and obtained, and to a certain extent even now seeks to justify striking out on the basis of a procedural failure, i.e. failure to serve the claim form in time. If the failure to serve the claim form in time is the cause of the strikeout, the exception to quox cannot apply, because even if there had been an abuse, the causative element is lacking. And to a certain extent, that is an end of this appeal. And one of the arguments we were running below...
Except that His Honour Judge Owen opened it all up. Or did he?
Well, I accept that he did open it up, and he opened it up in two ways. One, he opened up the question of what the judge, or the basis upon which the judge was striking out.
Well, it's perfectly clear District Judge Nicolle did not strike out on the ground of abuse.
No.
Did she?
No.
Nobody suggested she did. She struck out on the basis of late service.
She said, and I can take you to the transcript, that she would have struck it out as an abuse. She struck it out on service, but she would have struck it out as an abuse. She found there was an abuse.
She would have, but she didn't.
No, because she dismissed it on the grounds of service. So it was only on the question of cost that she said she would have struck it out as an abuse.
So it is common ground that the order below under appeal was not a strikeout on grounds of abuse.
No, it was, because the judge found that she had found that there was an abuse. Sorry, I'm standing up. I can take
No,
you
it's
to...
my fault. Don't worry, I'll be...
I can provide you with a citation on that.
We'll go to her judgment in a moment, but this in my submission is one of the difficulties. For example, in my learned friend's replacement skeleton argument, I think it's paragraph 53, if you allow me to turn it up, he talks in this way about what the judge would have done at first instance. Sorry, I think it's paragraph 48, actually, where it's addressed. He says, the district judge was invited to consider whether she would have struck out the claim as an abusive process, given the way it had been litigated. She found that she would have struck it out. So the way it's advanced in the skeleton on the appeal is that at first instance, this was a hypothetical exercise of, if you hadn't struck out the claim, would you have struck out the claim? Now, our submission is, if that is correct, and that is the basis upon which the judge was dealing at first instance, that must be an answer, because if she has struck out for the procedural failure, then that is the cause of the strikeout, and it is not permissible, certainly not under 44.15, to ask for a secondary strikeout to try and invoke quox. I accept that His Honour Judge Owen appeared to take a different view.
Sorry, invoke the exception to quox.
Sorry, yes. So if...
Yeah.
Yes.
Yep.
I think you misspoke.
Sorry, my apologies. I'll come on to His Honour Judge Owen in a moment if I can, but we say effectively that is the starting point and the end point. And there is a need to be careful about this because of the importance of preserving the predictability of Quox protection, because Quox protection is fundamental to access to justice so far as claimants are concerned. And can I ask you to go to the authorities bundle again? And it's the Aquile and Lawn Tennis Association case. It's tab 5 in the appeal bundle. And I wanted to have a look. It's the passage that my learned friend took you to on page 74. So paras 30 and 31, if I could ask you just to read those. That, to a certain extent, makes good the point I've already been making. There may be any number of reasons why a claim can be dismissed, including reverse summary judgment. So it might be a hopeless claim, but unless you are in one of those specified grounds, and there is a clear importance of protecting that. The other point I will make, and it may be that it's an obvious point, is, of course, what is missing from 44.15, which to a certain extent mirrors CPR 3.4, insofar as one has no reasonable grounds for bringing the claim and one has strikeout for abuse. There is no procedural default limb of 44.15. So a deliberate decision has been made that even if a claim could be struck out for procedural default under the CPR 3.4, that is not an exception to Quox under 44.15. That then brings me...
Why is that right? I don't understand that. If you find an abuse and strike it out under 3.4, why doesn't that apply 44.15?
Sorry, the point being, I accept that abuse applies in respect of each, but what is included at 3.4 but is not included at 44.15 is strikeout for failure to comply with a rule, practice, direction or court order.
I see.
So one can have a procedural non-compliance and a decision has been made that that is not an exception for Quox.
You sort of get the more open-ended, or the conduct of the claimant or a person acting on the claimant's behalf is likely to obstruct the just disposal. So there's a sort of conduct element in, but certainly you don't get replication if I think it's 3.4, the first one, failure to comply with the rule.
Exactly, and the point I would make in relation to 44.15, both B and C, is that for those, certainly if you are, well, certainly for abuse, you need to have a two-stage process. You have a finding of abuse, you then have an exercise of discretion, and so there is this double layer of protection there. So there has to be a judicial decision that not simply has there been an abuse, but that abuse is sufficiently serious to warrant the ultimate sanction, and it's only in those circumstances that Quox is applied. That then brings me to the application, and can I go to the supplemental bundle, which is where the application documentation is? And what I would like to do is, and again, I apologise that I'm going to a document produced by my learned friend, or that he's already taken you to, but it's page 148, which is the application notice.
So what are we doing? How the case was run below now?
Yes.
Right. So section 1 finished, now 2. Yep.
So the application notice at page 148, we can see that insofar as 3.4 is asserted, it's strikeout for late service pursuant to 3.4. Insofar as that appears to be anything, that appears to be failure to comply with the rule, practice, direction or court order. When one then goes to the witness statement in support, that begins at page 152. And I pause for a second on the opening page of the witness statement at page 152. This is a witness statement prepared on behalf of the director of the now defunct company. As I understand it, he'd instructed Direct Access Counsel at this point. At paragraph 4, at the beginning of his statement, he says, "These proceedings arise out of a claim for damages for personal injury allegedly suffered by the deceased, Ms. Rosa Taylor." So, of course, by the time this application is made, the proceedings have been served, albeit I accept based on the findings below served late. So they've had the particulars of claim. They know it's a personal injury claim. If they are competently advised, they know that we are likely to be in Quox territory, if I can put it that way, because it has been identified at the very outset of the statement that this is a PI claim. Can I ask you then to turn to page 154, which sets out the challenge to jurisdiction. And it's paragraph 15 of the statement that puts in issue the pre-action correspondence. This is why the pre-action correspondence was understood to be relevant at first instance. So if I summarise, and I hope I'm not being too glib here, an extension of time is applied for by those instructing me. One of the factors they cite is we've not had a response. What the defendant is doing is saying, well, I didn't respond for these reasons. Arguments on abuse are not being run, and that is certainly clear when one looks at, for example, over the page at paragraph 19, where the basis of strikeout is set out. And the strikeout is put on the basis of a breach of the rules or there being no real prospect of the proceedings succeeding because they're not valid. In fact, the only one of the CPR 3.4 factors that are not advanced in the initial application is the proceedings should be struck out on the basis they're an abusive process. I then want to run quickly through the evidence in response if I can. So can I go to page 211, staying in the supplemental bundle? So page 211 is the witness statement served by Mr. Mayor of those instructing me. At paragraph 12 on 214, he sets out his understanding of the case that is being run, so that we're dealing with strikeout on the basis the proceedings are served outside the 4 months. Now, I accept in passing that he says the defendant seeks a strikeout pursuant to CPR Rule 3.4a to c, but as I've already said, nowhere in the witness statement in support is abuse raised, and nowhere in the witness statement in response is there any acknowledgement or understanding that an abuse argument is being raised. And then we can see at paragraph 15 that there is reference to the assertion of prejudice. And insofar as there was a criticism at first instance, prior to the striking out of the claimant's pre-action conduct, it is that the anonymisation of correspondence had caused the defendant prejudice due to an inability to be able to investigate the claim. And that was prayed in aid as to why time should not be extended and all the proceedings should be struck out. It was not said to constitute an abusive process. The next paragraph I'd ask you to look at only briefly, it's paragraph 18 over the page, which sets out the number of contact attempts that were made by those instructing me to engage with the defendant in this case. Now, I'll come back to them in more detail under one of my later heads to explain the approach adopted, but I'd simply ask you to take note of the fact that this is not a claimant that simply issues proceedings or fires off one letter and then issues proceedings when there is no response. This is a claimant that takes a concerted effort to try and make contact and engage with this defendant. And that was a highly relevant factor that the judge below, His Honour Judge Owen, well had in mind when we were having the arguments about the approach adopted. Can I ask you then to turn to page 255, please, which is the evidence in reply from those instructing my learned friend. And at page 258, which is paragraphs 10 and 11 of that statement, or 10, 11 and 12, we can see the complaint that is made in relation to pre-action conduct. Again, noting in passing paragraph 10, this is essentially a claim for personal injuries following alleged disclosure of personal data which follows a specific format under the pre-action protocol. So the suggestion that the invocation of quox following the strikeout was entirely unexpected is hard to sustain in my submission. It must have been obvious that that argument was going to be advanced. But again, the key point being the arguments on the pre-action conduct went to this point on prejudice. There was no suggestion of abuse, and there was no suggestion that the claim should be struck out on the basis of abuse. Now, a submission made by my learned friend on, I think, at least 3 occasions in relation to why he said that His Honour Judge Owen was wrong to find that there was no abuse of process is because there was no evidence from those instructing me as to why letters were written in a certain way. The reason that evidence was not there is because that point hadn't been taken. These arguments about which protocol are you going under, are you trying to cherry pick to have the most favourable cost outcome for you, etc., they were simply not being run. In particular, what was not being run was any argument that there was an abuse sufficient to found a strikeout, such that a solicitor would think there was a need to fully explain why the approach that was adopted had been adopted. It was simply seen as being a prejudice argument. That then brings me on to the first instance decision and District Judge Nicolle's decision. Now, this is slightly confusing in that we have a transcript of the substantive decision, which was the decision on the jurisdictional points, and then we have the transcript of the hearing in which the judgment on costs is contained. The transcript on the strikeout is at page 32, and one can see very clearly the way in which at paragraph 1 on page 32 the learned district judge considered this matter was being advanced. This is simply a procedural application. It was no part of her understanding that what was being sought was strikeout on the grounds of abuse of process. So anyone having seen the evidence or someone in the judge's position would not have known that there was an argument such that some of the exceptions to the quox rules might have applied. Then can we turn to page 35 of the judgment, please? Because a lot has been said about the findings at first instance in relation to the claimant's conduct, but paragraph 13 is as far as they go, which is an acknowledgement that prejudice has been relied upon and an expression of sympathy. But that, in my submission, falls a long way short of any sort of understanding, let alone a finding by the judge, that there are arguments on abuse of process being run. So that's the substantive application. We then come on to the costs arguments. And can I ask you to turn to page 24 of the supplemental bundle? So at the bottom of 24, we see the space where that judgment was delivered. And then at the top of page 25, the district judge, I do not have a draft order. I do not think, Mr. Waite, but I grant the order as you seek. And then Mr. Waite refers to a draft order having been sent. It's not in the bundle, but I hope it's non-contentious that that order included an order striking out the claim. So at this point, before the cost arguments, there's been a decision that there will be a strikeout on procedural grounds. But insofar as there's any dispute at the bottom of that page, we can see an entry from Mr. Waite beginning, and I think, and this is him discussing the order, I was going to say paragraph 1 should say the service of the claim form be set aside. It just says the claim form be set aside. So it should be the service of the claim form set aside. And he goes on to say, and this is his point 3, the claim be struck out for the claimant pay the defendant's costs. So strikeout is asked for before any question of abuse is raised, the judge having already indicated that she adheres to the application for strikeout. And then one can see in the final sentence of that entry at the top of page 26, lines 3 and 4, we are asking the cost of the action because it is a strikeout, of course. So that's when these arguments start to be formulated. But in my submission, the only way in which one can fairly read that judgment is that the judge has decided to strike out for procedural default prior to the costs arguments being raised. So it is simply not open, or should not be open, to the defendant to argue that the reason for the strikeout is abuse of process. Insofar as His Honour Judge Owen took a different view, in my submission, he was simply plain wrong to do so, because it is plain on the transcript that the judge is adhering to the strikeout first. And in fairness to my learned friend, the passage of his skeleton that I've already been to, this appeal is put on the basis that the strikeout for abuse is a hypothetical strikeout as opposed to an actual strikeout, the judge having already made that decision. We then see the arguments that are advanced on the strikeout, and these are at lines 10 and 11. Quox is raised by my predecessor, Mr. Clark. There is then a response from Mr. Waite. Well, the exception to Quox is strikeout, of course, and service of the claim form out of time is an abuse of process, and therefore it is 44.15 that applies. Even if I'm wrong about that, you've got the whole Brown and the Commissioner of the Metropolitan Police, where you've got mixed claims. But the argument that is run, and again, sorry, this is repeated at lines 16 and 17, it is 44.15 that bites and tried to litigate, and it is an abuse of process to try and litigate on a stale claim form. That is the extent of the abuse argument that was put before District Judge Nicolle. Now, in my submission, that goes beyond actually what anything that was even hinted at in the evidence and the application itself, but that is a far more restrictive basis than was put forward on appeal. And then the argument, to a certain extent, is circular. I accept the main response being raised by my predecessor, Mr. Clark, was, well, there's nothing for you to strike out because you've struck it out already. And then one sees the ruling, and the ruling, this is on page 27, lines 26 and 27. The judge agrees that continuing with a claim where the claim form had been served out of time is an abuse of process, and the judge accepted that there was something still for her to strike out. So that's the way in which it's run at first instance. And I'm partly emphasising these points because we submit that insofar as there is a wider point of public importance in this appeal, it is what notice does a defendant need to give if it is going to run an argument that Quox does not apply. Because if claimants cannot issue personal injury claims, or can be in the midst of personal injury claims, can turn up to a routine procedural application that at face value does not expose them to any risk of losing Quox, and then can walk away from the hearing without Quox protection, that poses real problems to access to justice. I'm mindful of the time. I'd like to, I think, just get to
Carry on.
Slightly further on this point. So next we have the decision below of His Honour Judge Owen. This is in the core bundle, and I'd like to look at paragraph 65 on page 60.
Are there any rules about giving notice if you're going to rely on a Quox exception?
There is no rule, no.
Or guidance or practice direction or anything like that?
There is not. I suppose one of the difficulties comes, well, insofar as one is seeking to have a claim struck out on grounds that would disapply Quox, one would have to give notice of that application in the ordinary way under Part 23. Here, the notice given under Part 23, combined with the witness statement, is of a different application. I accept there is no procedural requirement to say that is what is being done. In my submission, it comes, I suppose, to the overriding objective and whether or not the judge at first instance should have entertained the argument in circumstances where, one, it had not been heralded before, and two, it had potentially an incredibly significant impact on the claimant. At the very least, as a matter of justice, the claimant should have known that was a risk going into that hearing, not least because the claimant may have decided, well, if it's a risk of me losing Quox protection, it may be that what I'm going to do is just discontinue these proceedings, bearing in mind if I just discontinue these proceedings and don't push this any further, a cost order on discontinuance is not enforceable against me, and then just start a second set of proceedings. But the claimant's deprived of that choice in this case, and potentially would be deprived of that choice in other cases. The judgment below then, His Honour Judge Owen at paragraph 65, he says, as a preliminary point, it is clear to me the learned district judge did strike out the claim. Paragraph 3 of the order says so. It is equally clear to me from the transcript of her cost judgment that she struck out the claim on the grounds it was an abuse of process. Now, I accept that in one sense, that is what the cost judgment appears to say, but if one then looks at the broader transcript, it is clear that before the issue of costs is raised, she has already adhered to an application to strike out. And the more important point, it seems to me, is that in my submission of proper reading of her judgment, the basis for striking out is not the abuse. The basis for striking out is the finding she's made that the claim form has ceased to be valid. So, insofar as I need to, I would submit that paragraph 65 of the judgment below is simply wrong, and that His Honour Judge Owen misinterpreted the judgment at first instance.
Is that a convenient moment?
That is a convenient moment, yes.
How are we doing for time? No pressure on you at all, Mr. Wibberley, but just roughly, how much longer do you think you have?
I'm about a quarter of the way there, which would need me leaving about an hour and a half after lunch.
All right. Perhaps you can go a little more, see whether you can compress some of that. We have the time available if necessary, but let's see how we go. Thank you very much
Thank you.
indeed. 2 o'clock.
Is it going to be locked over lunch? Perfect. It's a prep directly over the road, so we go out on the sofa.
Let's go.